All right, everyone, welcome to your high-speed revision class on the interpretation of statutes. We're going to make these core concepts stick so you're ready for anything. Okay, let's dive right in. So let's start with the central problem, right? Laws are just words on a page. And words can be tricky. They can be ambiguous. Parliament can't possibly think of every single situation. So when a law isn't crystal clear, that's where judges step in with their special toolkit to figure out what it really means. First things first, let's get two key terms straight: interpretation and construction. Think of it like this. Interpretation is like reading the instructions that came in the box. You're just trying to understand the plain meaning of the words. Construction is when you actually build the thing. You might have to make a few smart conclusions that go beyond the instructions to make it all work properly. Okay, so let's open up that judicial toolkit. We're going to start with the primary rules. These are the first and most fundamental tools a judge reaches for. And here's the first one. The big one, the literal rule. This is the oldest, most fundamental rule of all. It's super simple. A judge has to give the words in a law their plain, ordinary dictionary meaning. You just apply it exactly as it's written, no matter what the consequences might be. So what does this actually look like? Well, if a law says no vehicles in the park, the literal rule means you don't overthink it. Cars, trucks, bikes, they're all vehicles, so they're all banned. End of story. Simple as that. But, and this is a big but, the rule has a major trade-off. On the one hand, it gives us certainty. The law is what it says it is. But on the other hand, wow, it can lead to some really absurd results, or even cause real injustice, because it completely ignores the context. And that leads us to the crucial question, the one that requires a more sophisticated tool from our kit. What happens when following the words to the letter creates a totally ridiculous outcome? Well, that's where the golden rule comes in. You can think of it as a safety valve. It lets a judge start with the literal rule, but if that path leads to an absurd result, they can tweak the meaning just enough to get to a more sensible conclusion. It's basically a common sense correction. And this example just illustrates it perfectly. Let's go back to our park. An ambulance is literally a vehicle, right? But banning it from entering the park to save someone's life? That's absurd. The golden rule lets a judge say, okay, Parliament clearly didn't intend for that to happen, and they can allow an exception. All right, next tool up, the Mischief rule. This one's a little different. It asks the judge to be a bit of a detective. Instead of just asking, what do the words say, it asks, what was the problem, the mischief, that this law was trying to solve in the first place? And to do this, courts follow these four key questions that were laid down way back in what's known as Hayden's case. They look at what the law was before, what was wrong with it, how the new law tried to fix it, and the real reason for that fix. It's all about finding the original purpose. So, beyond those three big rules, judges have even more aids and different approaches to help them out. Let's expand our toolkit and look at a few of these. First up, we've got a fancy Latin phrase, noscitur essuies. But don't let the Latin fool you, the idea is super simple. It just means a word is known by the company it keeps. You figure out what a word means by looking at its neighbors in the sentence. And this classic example makes it crystal clear. If a law talks about cars, trucks, and tractors, the words around it create a clear category, vehicles. So if there was some unclear word in that list, you'd know it was probably another type of vehicle, not, a puppy. Now, these next two are kind of like opposing mindsets. With beneficial construction, a judge gives a law a wide, liberal interpretation to make sure it helps all the people it's supposed to help, like with welfare laws. But with restrictive construction, they do the exact opposite. They interpret it narrowly and strictly, especially if it's a law about taxes or punishments. Okay, so this brings us to the really juicy part. We've talked about the tools, but now let's talk about the person using them. A judge's own philosophy can completely change the outcome of a case. This is the big debate: judicial activism versus judicial restraint. So, what is judicial activism? Well, this is when judges believe their job is to take an active role in society. They use their power to protect rights and promote justice, sometimes stretching the meaning of a law to meet society's needs. And on the other side of the coin, you have judicial restraint. This is the opposite approach. These judges believe their role is simply to interpret the law exactly as the legislature wrote it. They don't try to fix it or improve it. They defer to the elected officials. This table here really just sums it all up, doesn't it? Activism is active and expansive. Restraint is passive and limited. It's a fundamental disagreement about the role of a judge in our system. And this quote from Justice P. N. Bhagavati captures the spirit of judicial activism perfectly. He's saying it's not about judges going rogue. It's about the court being a vital player in making sure democracy actually works for everyone. All right, finally, let's look at the very foundation of the whole toolkit. These are the guiding beliefs or default settings that a judge starts with. They're called presumptions. So these are basically the starting assumptions a judge brings to every single case. They presume the legislature intended to do certain things unless the law very clearly says something else. It's the invisible bedrock of how they work. And here are some of the most important ones. A judge will always assume a law is constitutional, that it doesn't punish people for things they did in the past, and, this is huge, that it doesn't intend to create absurd or unjust results. These presumptions are like a silent guide, keeping the law fair and stable. Which leaves us with one final thought to chew on. If the law is a toolkit, what is the judge? Are they just a faithful repairman, carefully following the instructions? Or are they a creative craftsman, using those tools to shape the law that we all have to live by? The answer to that question, well, it defines our entire legal system.